Please proceed.
May it please the court. I would request 5 minutes for rebuttal.
Okay.
I'm Mark Stope. I represent counsel for the appellants. Your Honors, this is an appeal that emanates from a summary judgment of foreclosure in a mortgage foreclosure case. I submit under a de novo standard of review. It's very clear that the summary judgment should not have been entered. I'd like to start with Rule 1.510C because I think this is the issue that clearly...
Can I just stop you before you get going?
Sure, Your Honor.
You have had the Brandeis case decided since you sort of wrote your brief on the 559 issue, and you've kind of argued that, that maybe we should reconsider Brandeis or this case isn't controlled by Brandeis. I assume you're going to touch on that, right?
Sure, I'll get to that.
And I'm not. You don't have to change your order for me. I just kind of wanted to get some understanding about how you're going to address Brandeis and encourage you to do so.
Sure.
Okay.
I don't think that drives the train here at
Okay.
all. I will get to that. I think it's obviously a small part of the discussion, but I don't
Okay.
think it drives the train at all. Now, Rule 1.510C, I think is what drives this train, and that rule provides that a movement for summary judgment in the motion shall state with particularity the grounds upon which it is based and the substantial matters of law to be argued, and shall specifically identify any affidavits on which the movement relies. Now, I ask Your Honors to look at this motion, this motion for summary judgment in this case. Made no mention of paragraph 22, no mention at all of 559715, no mention at all of any of our affirmative defenses, unclean hands, waiver, estoppel, set off for FDCPA violations, no mention of those at all. It made legal arguments regarding pro se defendants, even though counsel, myself, my firm, had been in the case for many months. It was clearly just a cut and paste form. It was clearly just a cut and paste form motion for summary judgment. Didn't mention any of those issues at all in any way. The only affidavit that it referenced, and 1.510C required that it specifically identify all affidavits, was an affidavit of indebtedness, and that affidavit, likewise, did not mention any of those issues. No mention of paragraph 22, no mention of 559, no mention of any of those affirmative defenses, completely omitted. Now, on those facts, my opponent says in its answer brief, in all capital letters and bold-face font, summary judgment motion states the matters to be argued. Your Honors, that is simply not so. Now, at the time that I drafted the initial brief,
Well, I think his big argument is that your affirmative defenses were not legally constituted. They didn't say anything.
And I'll get to that too. I think
not
that's
only
also
that, your affidavit and motion for summary judgment was a day late, and whatever arguments you raised weren't at issue and on deck.
I didn't even seek reversal based on the summary judgment issue. I didn't have to. I
Okay.
noted that in a footnote. That's not part of the argument or basis for reversal at all. Now, when I did the initial brief, I relied in that second point on appeal on the Alejandre case out of the 4th DCA from 2010. That was a case where the 4th District ruled that in a foreclosure case, that where the motion for summary judgment itself did not specifically identify the affirmative defenses in the written motion, that the reversal was required. To me, that case was on all fours and directly on point. But then it got even better than that, because after my initial brief was done, this court decided the Amstone decision on January 2nd, 2016. That case is on all fours. It's the spotted cow. There's no way around that decision. That controls the outcome here today. And in that case, because in that case, this court reversed a summary judgment of foreclosure. It cited Alejandre for the very same proposition that I cited it for. It cites Alejandre for the very same proposition, citing 1.510C, where a movement for summary judgment, the motion has to specifically identify the affirmative defenses and the issues that you're talking about. In that case, there was no mention of paragraph 22.
So if I understand your argument correctly, Mr. Stopa, it's if they're going to make the argument here on appeal that, look, these affirmative defenses weren't adequately pled, at a minimum that should have been included as a legal argument within their underlying motion for summary judgment.
Absolutely.
Okay.
And this court was really clear in ruling that way in the Amstone decision. And here's how clear it was, Judge. In that, if you read Amstone closely, the decision is really clear that in that case, there was actually an affidavit filed showing that a 22 letter had been sent. But because the motion itself did not specifically identify that affidavit, this court still reversed, even where there was an affidavit of record timely filed, because the affidavit was not specifically mentioned in the motion itself. That is what 1.510C requires. That's what this court required in Amstone. That's what the Alejandre court required. This plaintiff didn't do that. The motion's really clear in that regard. Now,
And in that case, the argument was also made that the affirmative defenses were legally insufficient, correct?
Absolutely. And here, and I have the case that's the case that is very compelling on that issue is called Elkins out of the 4th DCA that I cite in the reply brief on page 5. That was 4th DCA 1992. And that case very clearly provides that you cannot argue the legal sufficiency of affirmative defenses for the first time on appeal. That's quoted out very clearly, the 4th DCA's decision there, and that's what my opponent wants you to do. The affirmative defenses in the lower court, there was never a motion to strike them as legally insufficient. There was much less an order granting a motion to strike. So there was no reply filed, and there was no mention of the affirmative defenses in the motion for summary judgment at all.
And given the time frame that 1.510 requires between when a motion is filed and when a hearing is set, I believe your position would be, look, had they raised this issue in the motion for summary judgment, we could have perhaps taken some kind of corrective action as to those affirmative defenses.
Absolutely, because there's lots of case law that makes clear, you can get leave, if affirmative defenses are truly legally insufficient, you can get leave to amend potentially as late as the summary judgment hearing itself. But that's not an issue that you should be able to ambush or surprise the other side with for the first time at the summary judgment hearing where it wasn't in the written motion. And I cite the Cooper City case out of the 4th DCA from 1995, which tracks the language of 1.510C and actually holds the reason for the rule is to, quote, prevent ambush by allowing the non-moving party to be prepared for the issues that will be argued. And that's the argument that my opponent wants you to accept, is that they could ambush us either for the first time at the summary judgment hearing or worse yet, here for the first time on appeal, and argue that these affirmative defenses were legally insufficient for the first time on appeal when they didn't do a motion to, and it wasn't this counsel, so I'm not criticizing them at all. They're just the appellate counsel. But there was no motion to strike the affirmative defenses, no reply directed to the affirmative defenses, and no mention of the affirmative defenses in the motion for summary judgment itself. That's fatal. You don't get to come in now and argue it for the first time on appeal. And I know my opponent has no cases that they can cite where that was permitted. No cases where it was permitted to argue the legal sufficiency of affirmative defenses for the first time on appeal. And I have the Elkins case for you, that 4th DCA case from 1992. That may not be binding on you, but there's not a way to accept their argument without certifying conflict with that, certainly.
Walk me through one little twist that I understand your argument, what you're making. Rule 1.510 is a rule that requires particularity with motions for summary judgment. Just walk me through then, how do we align your argument here, which is that, look, they didn't comply with the rule, they can't raise it for the first time on appeal, with the notion that an appellee enjoys generally, which is that, the right for the wrong reason. Can you walk me through that twist, if you will, or that issue vis-a-vis having to address the issue that you're not? In other words, the summary judgment comes to us with a presumption of correctness, and if there's a right reason to affirm it, even if it's not stated in the underlying order, we're supposed to affirm. How do we align that then with the notion that, look, they don't get to raise this for the first time on appeal?
My response to that would be there's no case law that employs the Tipsy-Coachman doctrine in this type of context. This is not a right reason when it's something when they didn't spell these issues out in the lower
motion
court.
itself.
So I think that's the answer, and that's why there's no cases that employ Tipsy-Coachman here, is that you just can't do it. It's not the right reason. And there's not any cases that support it being the right reason on that issue at all. Now, I want to touch on the 559-715 issue. I'd love for y'all to go in bank and reconsider that and adopt what Judge Kuzam ruled. I don't think you're going to do that. I saw a chuckle from you, Judge Black. I don't think you're going to do that. I'd love to see you do it, but
We love an optimist, though.
even if it is a different court now, so maybe the change in structure of the court, changes the issue. But even if you don't do that, reversal is still required here. All these other affirmative defenses were not conclusively disproven. And I also note, if you look closely at that Amstone decision and the Brindis decision, all Brindis says is that it's not a condition precedent to foreclosure, where at trial, the burden of, this court said 2-1, that the burden of proof was not on the foreclosing plaintiff at trial to prove it as a condition precedent as part of its prima facie case. The Amstone decision from this court, in the summary judgment context in a foreclosure case, actually requires, when 559 is interposed as a defense, that the movement disprove the issue somehow with something. And maybe your honors think all that's necessary is to put in the motion and say 559 is not a legally sufficient defense or something, but I think that Amstone and Brindis can be reconciled in a way that supports my position to say, at minimum, 559-715 is not something that you can just ignore as a summary judgment movement when it is interposed as a defense in the answer. It may not be, as of the current state of law, it may not be a condition precedent, but it's not something that you can just ignore. So I think that Amstone is controlling on the facts there. And even if you don't agree with that, there's so many other affirmative defenses here that they didn't disprove at all. And for instance, on the standing defense, the third affirmative defense, standing is not only an affirmative defense, it's a part of the plaintiff's prima facie case. If you look at their affidavit of indebtedness, the only affidavit that was specifically mentioned in their summary judgment motion, that affidavit says that the plaintiff is the holder. There was no summary judgment evidence, nothing disproving our standing affirmative defense regarding this plaintiff not being the holder as of the inception of the suit. And I fought hard to get that Corrigan decision, which you all ruled on in Bank. The law on standing and inception is very clear at this point. So, you know, that's an example of how they didn't disprove our standing defense. They didn't disprove our waiver defense, which was the sixth affirmative defense. I think the facts in our waiver defense are similar to the Howdeshell case from this court decided in 1979, which I cited in the brief, that waiver is certainly a legally sufficient affirmative defense which precludes foreclosure. I submit, even if you do disagree with what I've presented so far as the procedural posture and how they waived the argument regarding the sufficiency of these defenses, I think the affirmative defenses are legally sufficient. Because if you look at them, these aren't one sentences like plaintiff's claims are barred by estoppel, period, and that's it, right? Each one of them has facts that support them. They have facts like, you know, the bank induced my client to default under the auspices of a loan modification by representing that, you know, if you need to default in order to get a loan modification, then they didn't give it to him afterwards. That's facts that I think support and make those legally sufficient defenses. That's something that they should have been addressing in the motion for summary judgment or somehow in the lower court at some procedural posture of the case, and they just didn't do it. And I think this is something, frankly, where, particularly after Amstone, that there should have been a confession of error. I would encourage your honors to ask my opponent how they can get around the Amstone decision, how that's not controlling upon you. I think it's clearly controlling and requires reversal on this fact pattern. And once the case proceeds to trial, you know, they may ultimately win, but for summary judgment purposes, this is not a case that should have been decided at the summary judgment stage. So with that, I'm happy to answer any other questions that you may have. Otherwise, I would save the rest of my time for rebuttal. Thank you, Your Honors.
You have 5 minutes for rebuttal.
Thank you.
Good morning. May it please the court. My name is Adam Schwartz of Ackerman on behalf of the appellee, and I thank you for the opportunity to discuss the issues presented to the court today. And when I first was asked to take this hearing this oral argument about 2 weeks ago, I had a chance to read through the briefs and the record on appeal, and I do think that there is a way through this record that would allow this court to affirm this final summary judgment, and we're going to have a wonderful opportunity to talk about that today.
You might want to start with Amstone.
Yes,
Because
Your Honor.
Amstone is staring you straight in the face. And
Yeah.
Amstone, you got it right here, basically says, the Amstone's remaining affirmative defenses were never sufficiently refuted by the bank. It's true that the bank did submit a response to the affirmative defenses, which we don't have here. There was no response.
Correct.
Arguing that they were legally insufficient, as well as an affidavit regarding the paragraph 22 notice. Well, the affidavit here doesn't really address the affirmative. Actually, it does. I'm sorry,
It does.
but the motion itself did not. right?
Well-
Or it didn't appear to, so maybe
Yeah.
if you have an agreement, if you have an argument as to why it did, you know, it'd be a good time to make it now. but-
I do. And Amstone is one of the cases that when I first read it, I thought that that was going to give us some problem as well. But I think that there's a way to distinguish that case sufficiently for allow this court to affirm the final judgment. So in Amstone, the plaintiff failed to address any defenses, right? Any, in its motion. Here, our motion did address affirmative defenses. It did. We addressed the affirmative defense of standing, which I think wasn't even adequately pled, but we addressed some of the affirmative defenses. The unrefuted evidence in this record established compliance with the condition precedent, and the motion referenced exhibits. The affidavit was one of those exhibits. There's an affidavit attaching a breach letter establishing it was mailed to the property address via first-class mail, and it complied with paragraph 22 of the mortgage.
Can
And
I back
Amstone-
you up a little bit?
Yes.
So you're hanging your hat on the word any affirmative defenses as opposed to some?
I think
Is
that
what you're trying to distinguish Amstone?
there's more ways to distinguish it, but I
Because
think
I
that,
don't see that language in Amstone. It just says address affirmative defenses. It doesn't say any or some. And it sounds like you're trying to, and I'm just trying to understand your argument.
Sure. When I read it, it appeared to me that there was a lack, or there was,
Total?
total lack of addressing any defenses, and it only addressed the plaintiff's prima facie case.
The Amstone opinion, the court says, however, the Amstone's remaining affirmative defenses were never sufficiently refuted, which would seem to indicate that some of them were, some were not. So, based on your earlier
Sure.
argument, you find yourself in the unfortunate same posture as the litigant in Amstone.
Yeah, and so, in light of that, and I appreciate that statement, it really, and it's funny, when I graduated law school, my uncle said the best answer a lawyer can give is it depends. And I think that if you start peeling the layer from Amstone and you go backwards, you go from Amstone to Alejandre to Frost to Knight, and you end up at Redding. Redding's a second DCA case, 1984. I have the citation here. And Redding's a very important case. One second, I'd like to give the citation. It's 452 Southern 2nd, 132. And in Redding, the court found there was no error in not refuting a legally insufficient defense in the motion for summary judgment, but that there was error for failing to refute properly pled defenses. And the cases since then might have diluted that underlying principle, but I think that that principle,
When Redding was decided, was the present verbiage of Rule 1.510 in place? Because the particularity that Rule 1.510 now requires for motions for summary judgment is, I don't want to say recent vintage, but it is in terms of how the law evolves, it is a relatively recent addition to motions for summary judgment. Rule 1.510 now requires particularity as to the legal arguments that you're going to make and the evidence you're going to rely upon, correct?
yes, yes it does. And on the page 1, and the appellant might disagree with what the particularity is, but on page 1 of this motion, it did track that language and identify at least what the plaintiff thought were the material issues with particularity. And that, I guess that would be my response.
Did the motion for summary judgment allege their defenses for conditions precedent are inadequate? Did it say that in the motion?
I do not believe so specifically.
I didn't think
said
so
that.
either.
I don't remember reading that in the
Did it
motion.
address all of the affirmative defenses in the motion for summary judgment?
No, and I think that in order for us to prevail here, we would have to have an understanding of what the paper issue line of cases means and how that applies to a 1.510 context.
What do you mean the paper issue?
Good question. Buried in footnote 1 of the initial brief is the phrase paper issues in quotations. I thought that that was very peculiar. And so I did some analysis of that. And it tracks itself back, and this is cited in the Houdsell case cited in the reply brief. In the paper issue line of cases, and I cite the Refex NV versus UMET Trust, it's 336 Southern 2nd, 473, it's a third DCA case, and it's cited in Houdsell, which is cited in the reply brief. And this is what Houdsell says. This is what Refex says. Quote, while it is true that it is necessary for a plaintiff to show that affirmative defenses have no basis in fact in order to be entitled to summary judgment, This does not mean that by raising purely quote-unquote paper issues, the defendant can forestall the granting of relief to the plaintiff where the pleading and evidentiary matters before the trial court show that the defenses are without substance in fact or law. And I thought it was interesting that it was buried in a footnote, so it made it clear, so it was presented to the court, but then there was no further analysis of it by the appellant. And I think that when you take that paper issue line of cases, and that was a foreclosure case, it was specifically a foreclosure case.
But see, Amstone addresses this very issue. I mean, it basically, you know, the bank did submit a response to the affirmative defenses. We don't even have that here, arguing they were legally insufficient, as well as an affidavit disputing the Amstone's affidavits that the evidence had not been received or was deficient. But the bank did not address the affirmative defenses in its summary judgment motion. I mean,
I'm doing my best to distinguish Amstone.
I mean, you know, 1984 was a good year. I still had hair then, but it was a long time ago, and this case is certainly eclipsed, you know.
Well,
that.
the other thing I would point out is in Amstone, the court faulted the trial court for not making any findings as to the affirmative defenses, but here the trial court did make findings on page 188 of the record. It said that there was nothing before the court that would prevent summary judgment from being entered. The court could review those defenses. There was evidence to support plaintiff's prima facie case, and the one potentially viable, or the two potentially viable defenses that were pled, one is a condition precedent, not even a defense, but condition precedent for the breach letter and standing, were refuted at the time of summary judgment. You have the affidavit from the plaintiff attaching the breach letter, the motion referenced exhibits before the court. That affidavit was one of the exhibits, and they, while maybe not articulately written, there was an entire page as to standing. So for the remainder of the affirmative defenses, I think that they are paper issues. They don't plead ultimate facts. And I guess that would bring me to 1.190E. And what does it mean to have substantial rights? You know, the 1.190E directs that the court, at every stage in the proceeding, is required to overlook any error unless it affects the substantial rights of the parties. And I humbly submit that you don't have any substantial rights in inadequately pled defenses. That's why they're subject to be...
I don't think anybody's asserting a right based upon a standard of pleading. Pleadings don't, you know, rules of procedure don't give rights, but I think what's being argued is that they had a right to have these issues tried, and that they assuredly had a right to. If it was not adequately addressed per Rule 1.510, and it doesn't appear to me that the trial judge actually made a particularized finding even on it, then they had a right to have those defenses tried, wouldn't they?
No, I think that you have a right to have a defense tried as if there's a disputed issue material fact that would overcome and prevent summary judgment. I don't think that you have a right to have your defenses tried if you don't submit any evidence in support of them or make any arguments in support of them. And I think that if they're legally insufficient, if they are truly paper issues, as presented by the Reflex case and as acknowledged in the footnote. I mean, if you look at page, I think it's page 4 or 6 of the initial brief, it even says that where defenses are sufficiently pled, the plaintiff has to overcome them on summary judgment. And then we go into this long discussion, but that's right in the very beginning. And I think that that's a beautiful application of the law. I really do. And I think that if we get back to Redding, and I think that we get back to Reflex, a defendant has to plead ultimate material facts in support of their defenses to make them viable. If you don't have any substantial rights in those defenses, and therefore there is no error if a plaintiff fails to, with particularity, explain why every unmeritorious or improperly pled defense would prevent, why they would overcome that at summary judgment. That will allow courts to do so much more justice. It would allow court system to flow so much better because you would not have gotcha arguments like this. These defenses are not meritorious. You have a defense that says that it would be unconscionable for the plaintiff to foreclose because of the ruin of the financial industry. I mean, that's one of the affirmative defenses we'd be reversing on so that we can have further argument, legal argument on that.
And your motion for summary judgment addressed that defense?
No, and no, it doesn't. And I, respectfully, I would be asking the court to take the position, and I am asking the court to take the position that if you don't plead legally sufficient defenses, either as a matter of law or because they don't have any ultimate facts to support them, then the plaintiff does not have the burden to refute them on summary judgment because you have acquired no substantial rights in those defenses. They would be subject to being stricken. And we'd be back to exactly what Reflex was informing everybody we wouldn't want to do, is have these gotcha arguments using up additional judicial resources over purely paper issues. I mean, I didn't choose the phrasing paper issues. That was the appellant burying it in a footnote to distance themselves for something that they know is probably accurate to these affirmative defenses. That application of the law, I believe, places the proper burden on a defendant to plead viable defenses with material ultimate facts and prevents, like I said, these gotcha arguments founded on paper issues. And because the defendant did not adequately plead viable defenses, the court did not err by granting the summary judgment motion. The affirmative defenses that arguably were properly presented were addressed at the trial court below. There was an affidavit attaching the condition precedent breach letter. There was an entire section on standing. The affidavit attaching the breach letter could be referenced as an exhibit when that term is used in the motion for summary judgment. The plaintiff respectfully and the appellee respectfully request the court affirm the final judgment of foreclosure. Thank you.
Thank you.
Your Honors, I've read the motion for summary judgment several times. I don't follow his argument at all that this references an exhibit that then references these other affidavits. I think it's really clear that the only affidavit referenced in the motion is the affidavit of indebtedness. That's in paragraph 1. The affidavit that referenced this paragraph 22 letter is not mentioned in this affidavit in any way, certainly not with the particularity required by 1.510C. So what I hear my opponent asking you to do is I hear him asking you to overrule the Florida Supreme Court in its rule of 1.510C, to overrule the Amstone decision and overlook that for judicial expediency, because if affirmative defenses aren't sufficiently pled, they should be able to overcome them and win anyway without having set forth those reasons in the motion at all. And as I indicated to you, there's no legal authority for that proposition at all. He has nothing contrary to the Elkins decision, which says you can't do this for the first time on appeal at a summary judgment, in a summary judgment posture. And I also cited in the brief, and I think they're not exactly on point, but I think that it's persuasive. There's a line of cases that make clear you can't challenge the sufficiency of the pleadings in any context, not just a summary judgment context, but for the first time on appeal. For instance, the Florida Supreme Court decision in Bank of New York versus Lemaire that just came out last year, the holding of that case was that failure to state a cause of action can't be raised for the first time in a 1.540 motion to vacate a judgment asserting it to be void. That's consistent with a line of cases that hold that failure to state a cause of action can't be raised for the first time on appeal. I read all those cases as very clearly providing you can't challenge the sufficiency of the pleadings for the first time on appeal. I haven't seen any, despite me having briefed that issue, I haven't seen any legal authorities for the proposition otherwise. No legal authority for the proposition that you can challenge the sufficiency of the pleadings for the first time on appeal, not in the summary judgment context or in any other context. I think the Florida Supreme Court's ruling in Lemaire is very clear on that issue. My opponent's argument about reference about paper issues, Judge, all that footnote 1 says in the initial brief is that these are not paper issues because we filed an affidavit supporting a bunch of those, which I didn't need to get into because of these other reasons, which we've all argued at length. But it's actually, the reference to the paper issues was to explain why these aren't, because there is an affidavit in the record that actually supports it. Now, I realize that it was untimely, and that's why I'm not arguing that, and that's not the basis for reversal. But to say that for my opponent to argue that these defenses are unmeritorious and just paper issues when there's an affidavit in the record that shows that we have support for at least some of them is not well taken. Also submit there was no contrary argument about how there was no summary judgment evidence showing their standing defense, not just standing as of the day of the affidavit, but standing as of the filing of the suit. Nothing at all supporting the requisite standing as of the filing of the suit. My opponent didn't even argue that issue in his part of the case. So I do want to briefly ask, if you're at all interested in that Brindisi decision and reconsidering that in bank, that as I've had a lot of time to think about this, and I have this issue pending in other DCAs as well, and this puts me in the awkward position of criticizing a 2-to-1 decision. I'm not intending to do that, but if you are at all thinking about this, what I would ask that you look at is that I think that the majority in Brindisi, when you're construing an issue of statutory construction, reads unlike any other decision that you would read on issues interpreting statutory construction, in that it doesn't start with the plain language of the statute, right? The court goes right to legislative intent. The dissent does great at interpreting the plain language of the statute. The majority doesn't do that. What does the plain language of the statute say? It requires that a notice be given 30 days beforehand. And I submit that is the fatal flaw in the majority's interpretation in Brindisi on 559-715, is that it doesn't look to the plain language of the statute first. As you look at any decision from the Florida Supreme Court on statutory construction, that's where it starts. What's the plain language of the statute? You don't just skip that and go to legislative intent and say, well, we don't think it was intended to imply in this context. So I think you're going to reverse based on these other issues, but to the extent you're at all thinking about that 559-715 issue, I would encourage each of you to think about it from that context. Thank you very much.
Thank you all. Thank you both. Good arguments. You're both ambitious. You want us to recede from Hamstone, and you want us to recede from